When you adjust the camera, it turns on. I'm working on a series of posts about probate. So when a potential prospective proposed executor brings me an original will, what do I do? Well, I need to take a look at the will, scan it, and make sure, in my opinion, at this stage, that it's a valid will. Not a deep search, but was it signed? Are there two witnesses? Is there an attestation clause? Right, just that look. I'll go into the elements of what makes a valid will in another video. But I will take that step, that process, engaging with the proposed executor. Now, then we have to create a petition and file the original with the court, the surrogate's court, at least in my neck of the woods. Other jurisdictions may call it probate court. But what about people getting copies? Well, before you file the original will, make a copy. Simple stuff, right? Do not remove the staples. There's the presumption that if the staples were removed, the will has been tampered with. Do not remove staples, but make a copy. And who will need the copies? Well, each of the proposed fiduciaries, if there's an executor or co-executor, beneficiaries, distributees, if ultimately a guardian ad litem is appointed, if you have that type of scenario. The casual bystander, probably not, but maybe people that were in the household. You want to have a couple of copies available. And then whoever makes the request, we can look at their standing or potential standing as to whether or not they're an interested person. And you may not be required to give someone a will, but it might ward off trouble and possible discontent if you do give a copy of the will. And we could go through that inquiry and whether or not that's a useful thing to do. And so in the office, I'll need a copy to be marked up. I'll need a copy potentially to send to an attorney that may become involved in a future adversarial proceeding. That's it, copies. All right. Be well.